focus on yourself, on your faith, on your dreams, on your mind, on your health, yeah. You gotta work, never tell, keep your head down, find what you love and excel, yeah. Push and pull and repel any hate, go create what you want, feel compelled, yeah. And once you finally get a taste of the race, you'll never look back once you felt that. Don't let somebody take your time and your worth, just focus on yourself first. Don't let somebody take your time and your worth, just focus on yourself first. Don't let somebody take your time and your worth, just focus on yourself first. Don't let somebody take your time and your worth, just focus on yourself first.
There we go. Isn't it cute? This little tiny little thing. It's so cute. It's only 20 seconds long, so I might check it out and make it a little bit longer, just so that people have a chance to come in when I go live. Yeah, come on in, everybody. Say hello, hello. We are going to continue with this trial of Ronald, who decided to murder his side girlfriend, his affair that he was having, and also their 2-year-old son. So we are going to continue with that. I still will give it just a few more minutes just to see if people want to pop in. I know there's some other people that are live right now. So I hope that they pop over when they're done with watching the other ones. So let's see who is okay. So Denise, hello. You were here way early. Lurker, hello, honey. You're so awesome. Mona Lisa and Petal. Not too many people here, but that's all right. I don't mind. I don't mind at all. So, okay. So we might as well start. Of course, just like every other one, I have rewound to this morning's so that we can watch everything, of course. I do believe that they are on lunch maybe right now. I don't know. They're talking about something else on Court TV today. They're talking about a different trial, which maybe we'll talk about later. But for now, I loaded and you opened and I clicked. Awesome. That's awesome. Hi, Blank Screen. How are you? How are you? We are watching this trial of this former Border Patrol agent who is accused of killing his affair. I hate calling her a side piece or I say side girlfriend. I guess it's a little bit better than side piece. But she was a side girlfriend, and he was married, and he killed both his girlfriend and their 2-year-old son, which is just horrific. So, okay, so let's get into this. Let's start going. I haven't watched too much of it, so it'll be a surprise, just like me, just like with you. So, sorry, today's just not a good day for talking for me. Oh my gosh, I fucking hate MS. Sometimes it just rattles your brain sometimes, and it just, I don't know. Some days are worse than others, but a blank slate. Hello, honey. How are you? His mistress. Yeah, but I hate that word, mistress. I just do. It's almost like like Pussy. I hate that word too, but so, but yes, Betel, yes. Noah Finway, hey, how are you? Okay, let's get going with this because we have a lot to watch, and I am going to speed it up a little bit, just so that we can get through just to 125, just so that we can get through this a little bit. Yeah. So let's start watching this. It's crazy.
Defendant Ronald Anthony Burgos Avalos stands charged by indictment with the offense of capital murder, but since there's two counts, we can just.
Could you put a copy on the Elmo?
Yes, of course.
So that we can. Thank you, Mr. Son. And that way you can point at the area you're talking about.
Yes, sir. So as far as this area, we would just need to add that it is two offenses. So here would be by indictment with two offenses of capital murder because there is two counts. I'm not sure if that would be an argument to make.
So where is that at?
It's the first paragraph of page 1.
Oh.
Right here, Judge.
It's because.
Would be two offenses of. Let me just try to see it.
So there's two counts?
Yes, Judge, because there's two counts.
So. Okay. Was that something you all did not agree with?
No, Judge, that's just something that we know right now whenever we.
Okay.
It
wasn't raised.
It was not raised.
No.
No, Judge.
I mean, in our position is that it's two counts of the same offense. I think they clearly delineated it later, but.
And then it would, I believe on page 2.
There's our liver girl standing up for her man.
So now you're going to whatever you all are.
Yes, Judge, this would be the
So
disputed
paragraph
part.
3 of page what?
Page 2.
Oh, I don't know why it keeps on.
All right.
So on this paragraph, we wanted to add this language which says that they can consider all relevant evidence pertaining to the relationship that existed between the deceased and the defendant. I know that the legislature does have some precursor language as far as the Texas Code of Criminal Procedure.
Oh, it's not even rewound.
Yes.
This is your.
God, that drives me crazy. I had it rewound. Sorry, you guys. Let me fast get going to where the court starts. I apologize for that. Firefox, yes, he did. Yes, he did. He lured them to a park. He lured them to meet him at a park. And
Us.
hang on a second here. He lured them to meet them at a park, and he used a sharp object to take their life. So yeah, and he actually slit the baby's throat. Isn't that horrible? That's awful. I hope this guy, it's a death penalty trial, and it's in Texas. So chances are he probably will get the death penalty. Yeah. And that's probably his best bet, in my opinion, because if this guy goes into general pop somewhere, he's not going to be a very happy person. So, yes. Okay, I found the beginning here. Oh my gosh, this is just driving me crazy. Okay, so sorry about that. We were at the end, but I don't want to miss any proceedings that we had this morning. So, sorry about that, guys. Anyways, let's go.
By 2:30 p.m.
Yeah, that poor baby. I agree.
2:30.
Available to testify.
He was 20 months old.
To clarify this issue, we looked into we spoke to our appellate counsel because this is a credibility question that belongs to the jury.
Firefox, I agree.
Suggest that it be testimonial and that she be cross-examined.
I will stop just for a second, just to Firefox. There's also a thought that he only met this baby twice, and the first time that he met him, it is believed that he injected the baby's leg with something, and shortly after, I think that the baby had trouble walking. So the day that this happened, the mom was going to take the baby to the hospital or to the doctors to try to figure out what was wrong with their leg, and this guy Ronald lured her in. I wanted to see the baby before he went to the doctors. And I think that was because maybe they might have done like a blood tests or something like that, and they might have figured out like what he injected. Also, when he was arrested and his patrol vehicle was searched through, they found syringes and needles in his lunchbox. So, yeah, kind of crazy story, but yeah.
Examined on this issue. We have no problem with that. And I've conveyed
All
that
right.
to council. They're in agreement with questioning her at 2:30.
Very good.
Is that okay with the court?
That's good with me. In fact, I prefer that as well.
Yes, Judge, and I think the district attorney has put it correctly that we believed we had a agreement, but the district attorney withdrew that agreement and then offered the testimony of Dr. Stern live. Judge, we would just ask if there is a question about the impeachment in order to be able to, that the district attorney stipulate to the letter that we have presented to them in its original form from the American Board.
Well, I mean-
if it's necessary for the impeachment.
But she never testified.
Well,
that's
in
right.
any event, the question is, are you going to be able to use the letter when you cross-examine her? And if it's for impeachment purposes, the rules are going to apply. Whatever the rules are, the rules are. I'm not going to make it. If you want to make a ruling right now, I will. But if it's going to be using for impeachment purposes, and basically that's, first of all, you're going to go through a clarification period, and depending on what she says, then this becomes relevant or not relevant, depending on how she testifies. So if she testifies, here I am, then, okay. Because it wasn't, she actually did not officially say she was. I mean, there was confusion and required clarification. And again, I don't have the official. I'm going with what Ms. Bozell showed us, but I do have Cindy going over that. So because we're going to have her here, and you have an opportunity to call her if you'd like, then that's the best remedy.
Yes, sir.
All right.
And I would say, for the record, of course, the CV that was provided by the district attorney for Dr. Stern under the category.
Oh, the garble before the court actually starts. But there could be something important in here.
Right.
So whether she technically, very lawyerly, on the stand, sort of mumbled through some words, may be different than what the records that she files as her curriculum. We can
Clarify the mumbling, if you want to call it that. Take it from there. But you'll have an opportunity to do that.
Yes, sir.
Okay. Then so it is. So you're, I guess it's 11:25, 11:22,
And Your Honor, just,
11:20 actually. I'm going by the cuckoo clock over here, but we're going with this one, 11:20.
and just to be clear, the state will be able to go after the question.
It's cross, a regular witness that they bring, and therefore you're entitled to cross them. Or
Yes.
whatever the rules say on that issue. Cross them, I guess, technically. All right.
All right.
Thank
you. So now,
I like this, Judge.
we just need to make sure our hallway is cleared for Mr. Burgos to go in, and then you all will follow, and then, of course, whatever time we have left after that is your sandwich or hamburger time or whatever it is you're going to have. Salad. Okay, salad. Thank you. We'll see you at 1 o'clock. Thank you all.
Oh my God, geez, seriously? Go to court and take a break. So I'm wondering, okay. Let's pause this for a second and let me go take a look because they're taking a lunch break right now. So there must be. Sorry, guys, I'm not very organized this morning, obviously. So, okay, we were actually, no. Sorry. Just give me a second here, you guys. I'm just looking. This maybe they didn't come to court until at that time, but I'm just looking to make sure that we didn't miss like the morning's procedures. So, I clicked on watch live, so it should be. Okay, so this must be it, I guess. Okay, let me bring this one up. Hang on just 2 seconds, you guys. I apologize. Let me look through. Oh my gosh, all these ads. I hate them. Okay, just give me a second here, guys, because I am going to pull up a different one that... Okay, this one is only 5 minutes long, so I think it is just like a review, maybe. Oh, I wish the time zones. I wish I was in this time zone so I could like not miss all the morning stuff. So, okay, I'm just gonna leave it on mute just for a second because this is just a commercial. Yeah, right. So if they give him life, he will be somebody's bitch, or they would torture him. If they put him in general pop. Yeah, exactly. So that's why I said like death penalty really is like his best bet, right? Because when you're on, on death row, I believe that you get your own little cubby corner, and nobody's allowed to get to you. So yeah, it's kind of crazy. Okay, so let's watch this. This is graphic. I don't know if I have any mods in here, but trigger warning, please, everybody, because I think this is a little bit of harsh coverage. He's talking about the wounds on the baby. So just let me put this in chat. And then, hi, Mitten, honey. How are you, girl? I'm glad you're here. Yes, this is going to be, thank you, sweetheart. I'm going to put that up on the screen there because he's talking about the wounds to the baby. So let's listen.
Dominic having what appeared to be a puncture wound on his thigh. Correct?
Yes, correct.
And you're aware that they claim that one of the 18 gauge hypodermic needle that was recovered from Mr. Burgos' patrol unit matches the size of the puncture wound on Dominic's thigh, correct?
Can you repeat that again?
Yes, sir. Part of the state's theory is that when Mr. Burgos met with Griselda Hernandez on March 25th of 2018 at Winfield Park, that he intentionally injected some kind of a foreign substance into the thigh of Dominic, and that it left the puncture
Hi, Running Bear.
question.
Yes.
You're aware of that, right?
Yes, I'm aware of that.
Hope you're having a good day.
So knowing that
checking
that
in.
is an important part of the state's case, you decided that
Still
you were
watching
not
this
going
trial
to
here,
make
so-
any investigation whatsoever to determine whether Mr. Burgos had a legitimate reason for being in possession of the hypodermic needle?
From what I discovered with discussions with Corinne Stern, that she believed that it was caused either by a 14 gauge or 18 gauge needle. I really just, needed for me to find that instrument that she believed that was used.
Was that the extent of your investigation with regard to that issue?
I believe so, yes.
Okay, so you did not investigate Dr. Antonio Rodriguez, the pediatrician who diagnosed the puncture wound as a spider?
Yes, yes. Yes, we spoke to Dr. Rodriguez.
And you learned that in his opinion, that puncture wound was caused by a spider bite, correct?
In
Or
his,
by an insect bite.
by an insect bite, because he was going off of what was previously told to him by the emergency doctors, or the emergency doctor's reports.
And you learned that Dr. Antonio
Okay, I'm just gonna pause it. Does anybody know, like, when you get a spider bite, isn't there 2 punctures? I don't know. I always thought a spider bite would be like two little punctures. I'm not sure though. So, anyways,
Rodriguez examined Dominic on 3 separate occasions, and on each of those occasions, his diagnosis was spider bite, and his treatment was for spider bite, correct?
Correct.
Did you also examine the medical records from doctors' hospital pertaining to this same so-called
I don't wanna just smack his
insect
face.
bite incident?
Correct. Yes.
And those records also indicated that the injury was caused by a
yes, they
spider
have
bite,
things.
and the
Yes, but a
treatment
needle
that was
shows the
recommended was
same.
for spider bite injury.
Okay, but a needle would be only
Correct.
one little puncture, right?
Did you also inspect the medical records from the emergency care clinic, which I think was a Vital Care?
Vital care. Yes.
And they also agreed in their diagnosis and in the recommended treatment that the puncture wound
Needle
on
shows the
Dominic's
type of
leg
glue, yeah.
was caused
I wonder if they
by
did, like,
some kind of
toxicology
an
on this
insect
baby.
bite, not by hypodermic needle, correct?
Correct.
Now, you found 2 hypodermic needles in Mr. Burgos' lunch bag, and you did not determine that he was prescribed testosterone. Do you know that testosterone is administered by an injection?
Yes, I have knowledge.
Yeah, Denise, I get needles all the
So
time. I only
that
have
would be a
one.
reason for
one
Mr.
puncture.
Burgos
So
to
I
be
don't
in
know, it's-
possession of those hypodermic
I don't know.
needles. Do you agree?
It would be plausible. Yes.
And as part of your investigation, you conducted a criminal background check on Mr. Ronald Burgos, correct?
Correct.
And you found that he has never been convicted of a felony or even a misdemeanor, and that he has never been arrested for any type of offense, correct?
Correct.
The only way it doesn't is the pain, yeah. Oh my god, seriously? I hate Court TV. Oh my gosh. Okay. Okay, so, oh my god, Court TV is just a pain in the ass. And let me bring that up again. God, it drives me crazy when it does that. It was only a 5-minute video though, so maybe it was done. Let me just check. You might hear it for a second here, you guys. I just want to check. Okay, so that video was done is why it did that. So, okay, let me just look one more time. I just want to make sure that we're not missing anything, which we probably are, but you know, that's okay, I guess. Whatever. Okay, I guess that's that was it. So Okay, so let's just continue with the one that we were watching. Give me a second and I will bring it back up. And Running Bear, yeah, it is an interesting question, eh? Like, I don't know, it's pretty interesting. I mean, it's plausible. Absolutely, it's plausible. I mean, anything really is, if you could explain it well enough, can be plausible. So, yeah, I don't know. It's okay. Let's take a look at this. I'm gonna let it play, but I'm gonna click forward because they just went on lunch. So. They take long lunches. Okay, come on. Is this just why would they put this video up?
The defense with regard to,
Sorry, guys. I just don't want to miss what he says.
to give instruction, and alternatively would allow Dr. Stern to be called as a witness for the defense so that they could put her on and clarify these testimony that in fact was given during direct, and so therefore she'd be subject to clarification, cross, and possible impeachment as well. So in any event, that is where we're at. And of course, she's not here until 2:30, I believe, because she was coming from out of town.
Leave your DNA.
And
Yeah.
so then our next thing that we have is in a minute when I bring the jury in, then and I'd like to be able to know now, after you've had an opportunity to speak to your client, what is it that you all, what witness are you going to call other than Dr. Stern?
Judge, we anticipate introducing some self-authenticating evidence and...
Can you get closer to the mic, please?
Oh, sorry.
Or you can come up here if you'd like, either way. Because I know you like to stand when you talk. Make sure this is on.
sorry.
Make sure that one's on right there. Thank you.
Judge, we anticipate introducing some self-authenticating evidence, and we do not anticipate having another witness outside of Dr. Stern.
All right.
So there is a timing problem if Dr. Stern...
I'm just going to go
Let's
forward
see
a
what
little bit. Let's get to the
Do
testimony.
you suspect you're going to have any objections to that document? We can, all right. So you can offer it then. You want to offer it when the jury's here?
Yes, sir.
All right.
And then...
And you're going to publish some of
In
it?
Tennessee, cab tech can only attempt
And of course, there'll be no testimony on it.
draw 20.
There'll be no testimony other than you publishing it.
Freaking comments being blocked off. God,
All right. Any other documents?
drives me crazy when I do.
No, sir.
Any other exhibit? Of course, something may come in with Dr. Stern, but I'm not talking about that.
We have no intention to do it until Dr. Stern's...
Okay, it's muted, so the jury must be coming in. Let's get this. Okay.
Oh, maybe you can ask her to park up here. Just drive completely up here. And then just have security, allow her to come up here on your end. All right, thank you. Just find out what she's driving. She's probably driving a truck. I'm just guessing. Okay, so trying to line it up so that we can, either way, we're going to have a whole bunch of breaks before we read the charge to the jury, because we have, obviously we have the break in the morning. We're going to have a break right now while we either, because we can't sit here having the jury here wait for 20, 30 minutes. So
Case small.
either just keep them going, leave them there for a few more minutes, I hope, but a few more minutes, meaning could be 30, 40 minutes, so, or bring them out and take them back in. Either way, and then we do.
Okay, I need to just pause for a minute. Case Smalls, Blunt B had a, hey Pussycat, how are you? Blunt B had a boys' night the other night, and all of us girls went and crashed their party. But apparently, you had to have balls to be there. So all of us girls, we all changed our names to like guy names. So, and I changed my name twice actually. I was first Forgotten Whispers the dude, and then I turned it to Forgotten Whispers uncle, and then I went to go change it back to just plain old Forgotten Whispers, and it told me, no, fuck you, you can keep that name for 2 weeks. So yeah, that's what happened. Yeah, it's crazy. Denise, yeah, it was great. It was really so much fun. I'm gonna actually go over that live because oh my god, it was so much fun. It was so funny. So funny. My cheeks were sore from laughing so hard. So okay, let's get into this.
We do the direct on the doctor, the recall of the doctor, right? Not even a recall, you're calling her as a witness. And then you examine her there, and then if you rest at that point, and I'm not holding you to that, but if you do rest at that point, then I gotta take the jury out. And then we gotta officially do the charge conference here, and then make my rulings, print out the charge, and take the jury out and come right back in. So that's basically the timeline that we're looking at, just so that whoever's wondering. So I suspect that the charge, I'm totally guessing on the length of the examination of the doctor. We're probably looking at maybe reading the charge to the jury around 3:30. So just a total guess.
Denise, yeah, you changed your name in chat. It was so funny. There were so many different names. Oh god, it was so funny. And sorry, everybody, I have to put your comments up on the thing to read them all because I just didn't.
I think
cut off halfway.
We're gonna have to do it at the end anyways,
Time.
because if there was a
I'm so dang it. I had memory yesterday and CT on my right leg with radiation and blood work. Thinking in advance. Of course, K Smalls. Oh my honey. All the prayers for you, darling. All the prayers for you. CT on your right leg. I had about a week and a half ago, 2 weeks ago, an ultrasound on my legs because I've been having troubles with my feet. They turned quite a nice purple color, so they're thinking I might have blood clots in my legs and stuff. So, which is not very good. But you don't know how to change your name. Oh, you just have to go to your profile and like you just go to your channel, your profile or whatever, and then like you just edit profile or edit account or whatever, and it will, and you'll be able to change your name. But don't do it too many times if you don't want to change it back, because you know I'm Forgotten Whispers uncle for like the next week and a half now. So, yeah. Okay, Smalls, yeah, you had that too. Ultrasound on your legs. Yeah, I never even knew that existed. Yeah, when I was like, they're like, oh, you're getting an ultrasound on your legs. I was like, ultrasound on my legs? What the hell? I'm not pregnant. So, oh. But it was kind of cool. It was interesting actually, like because you can watch it up on the screen what they're doing and stuff like that. And it was actually really cool, like to see the blood going through the veins and stuff. Like it was actually really cool. So, and I haven't heard anything back, so hopefully things are all good. So, anyways. Okay, let's get through this. They're doing a lot of talking this morning about, technical stuff and whatever.
Now and then give my official ruling right afterwards.
So,
that's what we do. But there is no language that they're asking for, no additional charge that they're asking for, other than just arguing some of the language.
I am going to go forward just a little bit. I don't want to miss too much, but
I would like to print this out without all the red line stuff that is in there. So if somebody can do that for us, please, and we'll take it from there, just so that I can file the copy we're working off of, and then I'll get a final one after we're done. You can, if you have it you can email it over here.
They're thinking
to Alma Martinez, but one that's not. I know there's probably just a couple of buttons that we got to push to be able to not.
Oh, I'm sure they'll be able to take care of you, honey. And you never have to shut up. Don't even say that. You can come here and you can talk about whatever you want. I have an amazing chat. I have amazing followers, subs, members, mods. So you will find.
So I'll file that copy,
and you're welcome to talk about anything you want.
We'll make them on the record. And
okay, these guys are just yappa dabba dabba.
This exact language in all prosecutions.
Highlights the state's theory rather than introduces any evidentiary principle or element of the crime which the state is required to. We would like to remove Roman 3, Your Honor.
we would like
Oh,
to keep.
all three.
Yes.
And then you want to add the word relevant.
Yes, Judge. Just so that it
You
can.
want to keep three and add the word relevant.
Yes, Judge. So that it can quote the statute directly.
Yeah, Denise, do it. True stalker. True Texan stalker. Yeah, do it.
Go ahead and tell me why.
Yes, Your
No, not you, her.
I think it's-
Well, Your Honor, that is language proposed by the state. We were unable to find it in any pattern jury instructions, and our position is that it's duplicative of the first sentence of Roman 9 and highlights the state's theory rather than introduces any evidentiary principle or element of the crime which the state is required to prove,
Roman 9. Okay,
which
Roman
instructs the jury that they may consider all of the evidence, which, necessarily encompasses any evidence the state has introduced as to the nature of the relationship.
9. If you tell me where Roman, I don't have a Roman numeral 9 paragraph.
Your Honor, it is on page, for my draft, 8, I apologize, Your Honor. It's page 4 on my printout.
Which
Yep.
paragraph is that?
Roman 8, my mistake. You may consider all of the facts that are shown by the evidence and draw natural and reasonable inferences from such facts. We believe that encompasses the specific evidence to which the state is highlighting in paragraph 3.
And so she says it doesn't exist. I know I've seen it before.
Yes, Judge, I've seen it. We have it in our jury charge or our pattern jury charges, but that language we included in every case, the one that she's citing to.
Other than you including the case.
Well, not those. I'm saying like the other language we always cite as far as all the evidence, but since this is a homicide, it does change and the law does give us.
Tell me the law instead of just,
Yes.
just reading the law?
So the Texas Code of Criminal Procedure, section 38.36,
me
gives
just highlight
this
it.
exact language. In all prosecutions for murder, the state or the defendant shall be permitted to offer testimony.
3836?
Yes, Judge.
One second.
He does, Firefox. I actually like this judge. Yeah, he seems to be like really kind of laid back and absolutely doesn't take no crap.
3836.
He's been a good judge.
AB.
It's 8, Judge.
Okay.
I am going to keep going forward though because, like, oh my god.
Is what they're, I think, saying in a different way. Or,
Version of both.
hold on. You didn't add it?
I believe that one's already a merged version of both defense and state's arguments as
So
to.
you don't want that?
We're just looking for
Okay.
maybe some
That's okay.
instructions on that.
All right, let's look. Okay, can I look at the paragraph right before that? Oh, let's see. Here we go. So it's the application paragraph, basically.
Yes, Your Honor.
I mean, it is what it is, right? I mean, they
Yes,
do
Judge.
have to
I mean, I just wanted some
unanimously
guidance. Oh, sorry.
They do have to unanimously find that beyond a reasonable doubt. I mean, I'm fine with that. I'll just leave the unanimously in there.
Okay.
All right, we'll leave the word, you wanted it in there.
We did, we added it in, Your Honor.
Okay, so we'll just leave it in there.
Okay.
Is there anything else? Mr. Sullivan?
And Your Honor, I apologize. I know I indicated several minutes ago that we were not going to request any additional instructions. However, we would like to request that Your Honor also instruct the jury in our book, which is an outdated manual, so I'm not sure if it's numbered differently in the state's copy, but in the 2018 version of the criminal pattern jury instructions, it's 9.16, instruction on warnings and waiver required for recorded oral statement. We would request that the court submit that to the jury as well.
Can I see what that was?
Yes, Your Honor.
Or do you want to put it up there? Sure. I can see it over here.
Okay, let's try and get past all this.
That way I don't have to type the language.
Yes, Your
out.
Honor.
And send the copy to council.
Yes, Your Honor.
Other than that, is there anything else?
No, Judge, I believe everything else.
Any particular place where you'd like that language? I take a look at it and.
Your Honor, I don't believe we have a strong position, but I would propose placing it between the application paragraph of count 2 and the paragraph now titled Roman 8.
Right, Denise, his next wife.
Roman 8, page 4.
So right before 8.
It's been pretty chummy, that's for sure. Okay, let's keep going. I mean, God. Bring in the jury, damn it. Oh, and now they're on a fucking break. Are you kidding me? Oh, my Lord, Lord. Oh, my God. Okay. Holy moly. Holy Spirit activate. That was ridiculous. Like, I mean, come on. Why didn't they tell you this is all technical stuff? Okay. Okay, well, they are on a break. Apparently. Maybe they have, I don't know, Court TV's got a different trial on right now. So let me check and see what's going on. Watch live. Well, I think that, like, oh my God, that's about it for court for today for this, actually. Crazy. Okay. Well, I will keep an eye and see and make sure that we watch if it comes back. So, did you guys want to check out the other trial that they are having on right now? It is hang up. It is Arizona versus Turney. Is that live right now? Okay, arguing statements. Sorry, guys, I'm just like bouncing around this. I'm just bouncing around Court TV site right now looking for. Okay, well, we will watch. Let's bring up this one here. And this is the next trial that they have. Like I said, I will keep an eye on they were talking about I think replacing a word and the like the technical blah 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 of the word that they were trying to replace. I believe that's what they were talking about. Anyways, I'm not sure. Sorry. I don't think I was like paying attention too much. All that kind of stuff just kind of bores me, like just get to the stuff, get to the real stuff. So, okay, let me bring this one up here. This is the next trial that is on Court TV. And this is a trial of apparently okay, they are on let's listen for a second here.
She didn't need to die that night.
It's just a commercial. So let's wait till they come back in. And this is hang on a second, you guys. I'm still with you. I am still with you. Okay. Well, Court TV is just doing its thing right now. It's just on a commercial. So we can just like chit chat for a second, I guess. We will as soon as this comes back on, we will jump in. And I also will look for okay, TV coverage. Let's check that out. There was this trial this morning, and I saw the opening statements. But maybe they just haven't uploaded it yet. Okay, let's watch this here actually, because this will tell us about like this next trial that's coming up. Oh, there's always a goddamn commercial. It drives me crazy when it does that. Okay. Sorry, you guys. I'm just like babbling here. I'm just going through the motions here. Okay, let's take that one away. And we will bring this one up. And this one I'll give us like just a little bit of a highlight about this next trial that is up. I think this is the right one. Hang on, the commercial's almost done. Okay.
Welcome back. Our next live trial begins tomorrow. It is the missing sister murder trial. Michael Turney is accused of killing his teenage stepdaughter, Alyssa, more than 20 years ago. Her body has never been found. The victim's younger sister, Sarah Turney, never gave up and turned to social media to keep attention on this case. She created a podcast, made TikTok videos about her missing sister. Here's a look at Sarah and Alyssa's friends remembering the victim on the podcast Voices for Justice.
What's your favorite memory of Alyssa?
Dancing around in her bedroom singing I Saw the Sign.
Drawing stupid pictures, laughing our asses off over absolutely nothing. I miss her a whole lot. You could not look away from her because she's just the sweetest.
She just had that really young at heart feel to her.
She could pick on you, but if anybody else picked on you, she was going to get them.
She made everything funny.
I don't feel like I ever had a friend like her, even to this point in my life. There was just something so magnetic and magical about her.
The picture that comes from Alyssa's 17th birthday, the one where she's holding out her hands in front of the cake, is one of my favorite pictures in existence of Alyssa. She's so happy.
All right. Opening statement scheduled for tomorrow. We're going to be there for it all. A lot of you have been waiting for this trial to begin, and we'll be there for it.
Okay, they will be there for it. Okay. Awesome. Oh my goodness. Okay, so that will be the next one that we are watching. So let's go back over here. I really don't know what's going good finally. Yeah. I don't know what's going on with the chat here, you guys, but it's really kind of fucking up. So I am going to try to
back into court where a jury in Phoenix is listening to the state's opening case against Michael Turney.
No blood evidence. There will be no DNA evidence. The police never found a crime scene, as you might have hoped they would.
I'm just gonna mute it for a second, you guys, and see if like we can go, if I can find
Let's talk
the
about that search
beginning of this
the
opening statement. I'll be right back.
defendant's home in 2008. What they discovered was that the defendant had literally hundreds of audio tapes of phone calls that had been recorded over the years. And I don't remember the exact number. Detective Summershoe and or Detective Anderson will be able to tell you that. Literally tubs of cassette tapes tubs of VHS tapes. This surveillance system used a VHS recorder. They found VHS tapes from years ago, years prior to when Alyssa went missing. Recorded phone calls years before Alyssa went missing. There was no recording of the day that Alyssa went missing. And as I told you earlier, no recording of that phone call. And there was a phone call to the residence. The defendant himself was able to obtain a record from the phone company. There was a phone call, as he described, from California. Obviously, the record doesn't tell you who called. You will hear that it came from a payphone, but there is no recording of that call. Sarah will tell you that all calls were recorded. This
granting the request for a single still camera to be in the courtroom during the trial. The court had previously taken under advisement the defense request that the pool camera not show the defendant's face. Did I accurately summarize the defense request?
Yes, Your Honor.
Okay. I have considered that request. I am denying the request given the fact that Mr. Turney's face is all over the media. I don't find any additional harm given the fact that the rest of the camera feeds will be showing his face, so that request is denied. I did receive a motion from the defense regarding requesting preclusion of certain evidence. Counsel, when is it anticipated that that witness would be testifying?
Okay, there we go. I can see chat now. Oh my goodness. Hey, Nikki, how are you, honey?
Why don't we do this, Counsel?
Good to see
We'll
you.
break for lunch a little early, and then I'll take up that motion.
Are you kidding? They're going for lunch.
I'll just ask, well...
Today's not the day
would
to
the
watch
state
court
refer
TV.
to that testimony in their opening statement?
Oh my goodness.
So I'll direct until the rules that nobody witnesses testimony, and if I'll try to break at about 11:50. I'll send the jury to lunch, and then I'll take up that motion. Let's see. Oh, Mr. Imbordino, you'd asked.
I'm going to try and skip through here a little bit. So we can hear the opening statements in this trial. Can you guys hear it? Yeah, I was going to say it's really quiet. I think it'll probably, like the volume is all the way up, so. Guys, Thursday, blame me. It's my fault Thursday. Oh, gosh. Oh, I hope everything went well, Nikki. I wonder our appointment turned into a 4-hour appointment. Oh gosh, yeah, right. Oh my goodness. Okay, let's get going here. Court TV. I don't think he's really talking quite yet. He's just setting things up, I believe. Come on now.
Let the record show the presence counsel, the defendant.
Okay,
Great
here we
morning,
go.
ladies and gentlemen. It's great to see you all back. It seems
I hope you guys, it is kind of
since
quiet. I'm not
we
sure
together,
why.
But I'm glad that you were all able to make it back today and in time. So thank you so much for that. So when we were last together, you were sworn in as jurors. At this, let's see, have you read the charging document already? Okay. So at this time, I'm going to ask the clerk to read the charging document to the jury in just a moment. Hold on. We just need to get him his listening device.
That's weird. They must have it muted or something. I think she's just reading jury instructions, so maybe they have that muted. I'm not sure. I do somewhat hear something though, eh? I think it'll get better in a second. Just hang on, I hear you guys. And if it doesn't, then there's another trial that we can watch.
Next will be the reading of the preliminary jury instructions. You should all have a copy of the preliminary jury instructions in your notebooks. Feel free to read them along with me or just to listen as I read them aloud. Are there any jurors who cannot locate a copy of the preliminary jury instructions in their notebooks? Looks like you've all found them. Counsel, you have copies as well?
Yes, Your Honor.
All right. CR 2020-001818-001, State of Arizona versus Michael Turney, preliminary instructions. Importance of jury service.
Yeah, the chat is
Jury
being really
service
weird.
is
Eh?
an
It's
important
like,
part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury
chat is
system
being
as
funny
an
for me too,
effective
Nikki,
means
so
of drawing on the
what's going
collective
on.
wisdom, experience, and fact-finding abilities of persons such as yourselves.
Probably
While it
restart
may be
if I
an
haven't paid
occasional
for it yet.
inconvenience or worse, jury service is an important responsibility for you, one which I am sure you will take seriously. Duty of jurors. Ladies and gentlemen, now that you've been sworn, I will briefly tell you something about your duties as jurors and give you some
Okay, I'm going to
instructions.
try and skip
At
through
the
this
end of the
because I
trial,
think
I
we've
will
all
give
heard this stuff
our
1,000
judges
times.
facts. You will decide the credibility of the circumstantial.
I saw
on
using
what is
all
and
the
what is
same garble that they give to, is that me? Stop. What? What's that? I don't even know why they have those top chat and side chat. I just don't even get it. I don't even get it. It's just insane. It's stupid. Okay, there we go. Thank you. Somebody pushed the play button. Did you see that little hand come out? That was the me. Oh, Court TV.
unless other
really,
arrangements
really getting to me
and
today.
you should understand that those are to reject.
That's
You may
like,
accept
yeah, I was-
everything a witness
I'm
says,
like,
or
what?
part of it, or none of it. In evaluating testimony, you should use the hearing or seeing done. You are to determine Twitter exactly what evidence you should overhear. In a civil case, the jurors
Oh, God.
concerned about them do a direct examination.
I don't know why they don't do this, like,
If the rules permit the question and the answer is available to a law enforcement
I guess
officer,
they have to have it on
to be
record.
innocent.
So,
The state has the burden. The defendant is charged. The defendant is charged with 1 count of second-degree.
oh, let's listen to that.
Or number 3, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The defendant has pled not guilty to the charge. The state must prove each element of the charged crime beyond a reasonable doubt.
You're right.
I will give you more details and
I
definitions
agree.
about the alleged
It's
crime
fucking
in the
idiot. It's
final
just-
jury instructions.
They're just trying to fuck.
Scheduling during trial. The trial is expected to last through Thursday, July 20, 2023. We will all do our best to move the case along, but delays frequently occur. These won't be anyone's fault,
Like
so
this
don't
morning?
hold them
Come
against
on, I haven't
examination.
barely watched any.
This usually
at all.
ends the test. The case I will read to
Feel
Okay.
free to raise your, when we were here, I think I told you that sometimes I tend to be soft-spoken, so I'm going to speak into this microphone.
Looks like you've been a lawyer for a long time, so you should learn not to be so soft-spoken. Okay, here we go, guys. This is opening statements in this trial.
Remember the other
Of,
day, welcome back. Thank you for your kind attention. The other day when we were here, I think I told you that sometimes I tend to be soft-spoken, so I'm going to speak into this microphone. Feel free to raise your hand at any time if you can't hear me. Same for anyone. If you didn't hear one of us ask a question, feel free to let us know. Just a couple of preliminary matters. A couple of them were covered by Judge Myers. First of all, this opening statement is meant, I will attempt to give you an outline of what I expect the state's evidence to be. I won't discuss every witness. I won't discuss in this opening statement everything that I think they will say. The purpose is just to give you some expectation of what you will hear. In just a minute or two, I'm going to begin talking to you about Alyssa Turney. Try to give you some sense of who she was, what her life was like, who her family was, those kinds of things. Another thing I want to let you know is that occasionally you may hear a party request, the state request to put a witness on out of order. In other words, they may have testimony about an issue that actually somebody else has already talked about. And you might wonder, well, why weren't they called first? Well, witnesses have lives just like you do, so we attempt to make life a little easier for them to get here, not interfere with their work schedules as best we can, those kinds of things. Third, as you will hear in just a moment, there will be people testifying in this case about events that happened in the late 1990s, early 2000 and 2001. So for some of those folks, we're asking for their memory of events that occurred some 20 to 25 years ago. I'm telling you this because what may happen with an individual witness, they may not recall something that they said 20 years ago. So occasionally you will may see that witness presented with a copy of a police report, documenting an interview they did those 20-something years ago. It may refresh their memory, it may not, but that's a process that you will see take place, I expect, in this trial as it does in many other trials. All right. State of Arizona versus the defendant, Michael Turney. You'll discover throughout this trial that I'm not the world's greatest at electronics. So let me see if I can, well, I may just have to do it by hand. This was Alyssa Turney. Alyssa Turney has not been seen alive since May 17th of 2001. The evidence will establish that despite efforts to locate her in all these years, her body has never been found. Her stepfather was the defendant. You will hear
Tragedy
testimony
Pam's
about her
Exposed.
family.
How are you?
There were
Thanks for
her
coming
younger
in.
sister, his name is Sarah. Sarah will be testifying in this case. She had brothers, James, John, Rhett, and Michael. Some of those brothers were stepbrothers, if you will. John and Alyssa had the same mother. Their mother married the defendant. The defendant had sons, Rhett, James, and Michael. So these families joined together. They lived in various locations, but at the time that Alyssa was murdered, they were living at 17217 North 34th Street here in Phoenix, Arizona, Maricopa County. Alyssa was, I believe the witnesses you will hear from are many of her friends, her family members.
How's the sound for you guys? Are you guys able to even hear?
I expect that.
Yeah, I was just going to say that. Someone give him a cough drop.
Established that Alyssa was pretty much a typical.
Dude, take a drink or something.
She was 17 years of age, had just turned 17 very recently, prior.
Oh, this is driving me crazy. Okay, maybe we'll go over this one tomorrow because this is live. This is live today, and I don't know. They keep pausing it. I don't know what's going on. So I saw this other thing actually that I thought maybe would be really kind of cool. Okay, give me a second here. Okay, there's another trial that's coming up, or it might be in, I don't think it's, sorry about that, guys. I'm sorry, I switched. He's a very monotone speaker. Yeah, I don't know. It was really hard to hear. So we can go back to that, once it's maybe been like posted as not live, so much. But I thought maybe we'd take a look at this one. And this is the trial of a young man. His name is Jeremy Goodale. And he is accused. He's facing 30 years in prison, 30 years to life, for his role in a brutal killing of a high school Spanish teacher. Willard Chaden, that's a cool name, Miller and Jeremy Goodale were 16 years old when they murdered Nohema. Okay, I'm not muted. I'm just talking away here, making sure I'm not muted. Let me bring this up so you guys can see actually what I am looking at. Sorry, this is like things are not really kind of working out this morning, but we'll figure it out. There's always something to watch, right? There's always something to talk about or something to watch. And you know what? If after this, there's some shit we can talk about too, right? There's always shit talking to do. But live stream is being really dumb. Okay, there we go. Okay, so this is a trial of these two teenage boys who murdered a teacher of theirs. And we will just read here. William Chaden Miller and Jeremy Goodale were 16 years old when they murdered Nohema Grabber, 66, on November 2nd, 2021, just days before the jury's selection was set to begin in his criminal trial. Miller pleaded guilty to first-degree murder. Okay, so this is an interrogation video that I thought that we could take a look at. It might be kind of interesting, so let's watch this one. Definitely trigger warning, because this is probably some her stuff. So, volume all the way up. So let's check out what this is all about. Come on, Core TV, come on. So this is actually his sentencing because he pled guilty. So I imagine that they are just going straight to sentencing. Let me talk through those.
With regard to corrections, I believe that a sentencing memo has now been filed, and that sets out a number of minor corrections, ranging from, I think that within the PSI gives my client's height at arrest, which was 5'6", he's now 6'4", to some corrections as to my client's perception of some minor notes within the PSI. None of those should interfere with this court's ability to use the PSI and to rely on the PSI for sentencing.
And has this Did the state receive a copy of the sentencing memo?
Judge, there's been a reference to the sentencing memo here on the record, as well as prior to coming in here this morning a few minutes ago. I do not have a copy of that yet. I'm not sure when it was filed, but I don't see any reason why we can't proceed regardless.
I just printed off a paper copy for counsel and myself. I don't know if, so I'll give you guys, everybody has a copy of it.
And Your Honor, I did just hand my computer to Mr. Molden to review those corrections, and he had an opportunity to look through those.
We'll wait for Carrie to get back with those memos. Counsel, do either of you or any of you know of any reason why judgment and sentence should not be pronounced today against Mr. Miller?
No, Your Honor.
No, Your Honor.
And Mr. Miller, do you know of any legal reason why I shouldn't sentence you today?
No, Your Honor.
With regard to the sentencing hearing, I'll allow the state to put on its evidence and argument first. Then the defense will have an opportunity to do the same. Mr. Miller will have an opportunity if he wishes to make a statement before sentencing, but it's not a requirement. And then we'll have any victim impact statements read after all those things occur. But we'll start with the state, and is there any evidence you'd like to offer this time, counsel?
There is, Judge. If I could just briefly outline that for the court so you kind of know what you're in for, if that's okay.
Go ahead.
So it's our intention in our presentation to offer 4 witnesses. Trent Billida, who is the DCI agent, who is the assigned case agent for the investigation of the death of Noe McGraber. He will testify to kind of give the court and everyone an overview of the investigation and the evidence that was collected by law enforcement. Secondly, we're going to call DCI Special Agent Ryan Kedley, who will provide a summary of the interviews of both the defendant, Willard Miller, as well as the co-defendant, Jeremy Goodale. We do have some excerpts from those interviews that we will play for the court. Total minutes on the excerpts was right around 50 minutes, I believe. Thirdly, we're going to call Fairfield Police Officer Julie Kinsella, who was the lead officer and detective that assisted with the investigation into the death of Noe McGraber. And then lastly, we're going to call Mike Heinrici, Heinricy, who is the warden of Iowa Medical and Classification Center at Oakdale, which is the reception center the court is aware for all prisoners. He also was one of the persons that spearheaded the youthful offender program at Oakdale, because it is our understanding that whenever the defendant goes to prison, he will initially be in that program. So I think he has some relevant information to offer, not only initially with the youthful offender program, but then what may be in store for the defendant, depending on his length of sentence that the court imposes on him. So that's our presentation of our evidence. We also have, one other thing that I might mention, as the court is aware, under these circumstances, and since the defendant was under the age of 18, whenever he committed the crime that he's pled guilty to, Iowa Code Section 902.1 sub 2B 2A provides a number of factors for the court to consider in fashioning an appropriate sentence. I won't go through all those factors, For the court, I know that you're well aware of those, but all of our evidence that we have today will impact one or more of those factors that the court has to consider in fashioning the sentence for the defendant. We are going to be recommending at the close of all the evidence today, whenever we do make our sentencing recommendation, that the defendant, Willard Miller, be sentenced to a term of life with the possibility of parole, and that he be made to serve a 30-year minimum sentence before he is eligible for parole. That was our agreement with the defense. Of course, they can make any recommendation that is legally available to them, but that's what the state will be recommending in this case. And lastly, before I call any of our witnesses, Judge, we do have a number of exhibits that we are going to be offering. For the record here, we have numbered them 100 through 133. Inclusive of all those numbers, we have provided an exhibit list to the court which details what those exhibits are, describes them for the court. We would offer those collectively at this time, exhibits 100 through 133. There are several photos in that on that exhibit list that show Noe McGraver at the railroad tracks where she was found. They're not pleasant pictures to look at. I know some of the family here has been notified of that. I'm not sure all of them have. So by way of this statement, we're letting them know, and those pictures are 123, 124, 125, and 126. So there are 4, I believe. So just by way of noting those for the record, so we would offer those exhibits at this time, and then we would be prepared to call our first witness. Thank you.
Regarding the exhibits offered by the state. Your Honor, we do object to exactly the photos just referenced by the state. That's 123 through 126. Your Honor, those are not probative on any issue of sentencing. I understand that the state's argument is that those would go to the nature of the crime, but the photos don't depict anything not within the autopsy report, not within testimony, and in this case are unfairly prejudicial. If the court accepts the photos, we would ask that the court limit publication of those within this courtroom. Certainly there is nothing that must be publicly viewed in order for the court to make whatever consideration the court makes, and charging the situation even more within the courtroom does present a danger of unfair prejudice. Mr. Brown, you would offer state exhibits 100 through 126 at this time?
Correct. Judge, if I may, just for the record,
go ahead.
Part of the factors under the code section, may I remain seated? I don't mean to be disrespectful. Okay. The factors under 902.1 that the photos that we're offering goes to would be the severity of the offense, the nature of the offense, the heinous, brutal, cruel manner of the murder, and the
I appreciate you guys.
If I didn't mention severity of the offense, it goes to that factor as well. So it impacts several factors under 902.1. I would tell the court that there are a number of pictures that we have. We have limited this to 4 photos. We're also offering the autopsy report as part of our exhibit list. But all of those things, I know they're not pleasant to look at. I understand that. But that should not keep them from the court's consideration or the public's view, since this is a public hearing. So we would resist the defendant's objection on those grounds as well.
Any further record we need to make on those exhibits?
I don't know why it's like small.
Your Honor, I understand that the rules of evidence are not the same within the sentencing procedure, but the constitutional protections are still applying. I think that's within Gideon versus Wainwright. And Your Honor, creating that public photos does not serve any significant aspect of sentencing, even in showing the severity of the crime. The photos don't depict anything that really shows much about the crime. They're just very sad photos, and it creates the danger, again, of creating emotional charges going forward.
Don't even see me, John.
I'll,
you guys, hang on.
Over the objection of defense, I'll admit State's Exhibits 123
It says
through
page
126.
unresponsive. Are you guys with me?
And I'll admit 100
Am I
through
still live? What's going on here?
122 without objection.
Oh, something's happening. Maybe it's my content today. Yeah, it's just, you know.
Does the state have any objection to the defense's exhibits?
No, we were provided a fairly comprehensive list of the exhibits they had. I don't believe we had any objection to any of them. Judge, I want to make sure we're clear on numbers.
Yes, okay.
Your Honor, you admitted
on my end,
all the exhibits
my
up to 126. The state has also offered 127 through 133,
unresponsive.
which are the autopsy report and video records, as well
Keeps
as some
doing
evidence
it.
from the defendant's cell phone.
Then I'm probably like, I'll just stop
And
restart the live.
position on the admission of those exhibits.
I don't know how to do that, but I just have to start another one, I guess.
One moment.
Or we can just like completely forget about court today and talk some shit. Because there's lots of shit we can talk about.
Your Honor, we don't object.
I mean, Molly is
to
on,
admission.
Molly's on Fix right now.
Certainly there's argument
Scream her.
to be made as to the weight to be given by the court. This is an unsworn statement, and the speaker is not available for cross-examination. I think without the ability to confront that statement, minimal weight should be given, but we don't object to its admission.
One moment, Your Honor, I'm sorry.
And Your Honor, that's to both 129 and 123, which are essentially the same thing as the video and the transcript.
I see 127. I don't see 129. Is there a 129, Mr. Moore?
There is, Your Honor. 129 is a video interview with defendant Jeremy Goodale.
Judge, obviously the videos we can't upload, that may be what you're looking at. We have those on a flash drive here for the court, so both interviews in their entirety.
Is it the same videos offered during the suppression hearing?
The Miller interview would be the same one, but the interview of Goodale I don't believe has ever been offered in a hearing, not to my recollection. He had proffered with the state in February of this year. That's that interview. It's a little over 2 hours in length.
Well, I will admit states 127, 130, 131, 132, and 133. And I'll admit exhibit 129. Is there a 128?
128 is the video interview of the defendant, Miller.
Okay,
Yeah.
so I've already watched that, but I will admit that as well and give it the weight I believe it deserves. Regarding the defense exhibits, I believe it's MMM through MMM, triple M through triple Z, and then quadruple A through quadruple C. Any objection to those exhibits from the state?
Your Honor, may I be heard? We have not offered those yet, and I'd like to wait until our evidence begins. We may limit some of those.
Okay. Is the state ready to proceed with sentencing?
We are, Judge.
Okay, go ahead.
Our first witness is Agent Trent Belden.
You promise to refer to tell the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat.
Good morning.
Good morning.
Can you please state your name for the record?
My name is Trent Villeta. It's V as in Victor, I-L-E-T-A.
And how are you employed?
I'm a special agent with the Iowa Division of Criminal Investigation.
And how long have you been employed in that capacity?
Since 2006.
All right. And where is your current assignment?
I work for the Major Crimes Unit based out of Cedar Rapids.
Okay. Can you describe for the record what the Major Crimes Unit, what their function is?
Sure. It's the Major Crimes Unit is essentially a violent crimes unit. We are an assist agency, so we offer expertise in death cases, officer-involved shootings, other violent crimes that maybe smaller departments won't have. And so when something like a murder happens in a smaller community, we will work with that department during that investigation.
Over the years, do you know how many death investigations you've worked?
I've been asked that quite a few. I'm not sure. A lot.
So in this particular case involving Noema Graber, were you assigned to work the disappearance and ultimately the death investigation involving her?
Yes, I was.
And when did you get that call?
We got that call on November 3rd in the evening, approximately 8:30 or so.
Can you just describe for the court how that process occurs?
Sure. As a request agency, we have to be requested by a police department, a sheriff's office, county attorney's office. So my supervisor at the time received a call from the Fairfield Police Department regarding a missing person. As I was coming down towards Fairfield, I was notified that the missing person's body was located.
And who was that?
It was Noema Graber.
So about what time did you arrive here in Fairfield?
It was sometime between 9:30 and 10 p.m. on November 3rd.
And can you generally describe for the court how it was that Noema Graber had been located by local law enforcement?
Sure. The Fairfield Police Department took the initial missing persons report. They conducted a very thorough investigation as far as a missing persons investigation goes. They had worked, I think, pretty much maybe 12 to 15 hours so far. During their investigation, it was determined that every day at 4 p.m., Noema Graber would go to Chautauqua Park and do 3 laps at the park. So they were able to determine that she was last seen at 4 p.m. on the 2nd, leaving the school, and it was a logical next step for them to search the park.
And was there a vehicle that was associated with Noema?
She had always drove a van, and that van was seen entering the park around 4 p.m. on November 2nd.
As you didn't mention, there was surveillance video check at the school to determine the exact time that she left on November 2nd.
That is correct. There was video of her leaving shortly before 4 on November 2nd.
Right. Now, the report of Noema Graber's disappearance did not come in until the following day on November 3rd. Is that right?
That's correct.
Can you just generally describe for the court what the circumstances of that particular notification were?
Her husband, Paul Graber, had come to the Fairfield Police Department, I believe around 8 in the morning after Noema did not return home on the 2nd.
Had Paul Graber been out of town on November 2nd as well?
That is correct.
And did they live in the same house together here in Fairfield?
They did.
Did anybody else live with them?
They have a a son that lives with them.
Had you or other law enforcement, prior to knowing prior to her being found, had anyone contacted the school to see if she had?
Okay, this restream keeps fucking up on my end. So I am going to just refresh and see if it's still here for a second. So give me a second, you guys, because on my end it's like really fucking up and it's pissing me off. So hang on, I'm just going to refresh for a second. And then we'll go on to something else. We'll start talking some shit. Okay, it's still going. I can't access chat. I don't know what's going on. Oh, it's pissing me off. Okay. It shows that my voice is coming over. So, okay, you guys, I am going to quit this one because it just keeps screwing up over on my end. And I'll be back like maybe I'll be back in about an hour. Let's do that. Let's take an hour break, and then when we come back, we're gonna totally switch it up. I don't know if it's because like Court TV is being funny and it's affecting my restream. I have no idea. I really have no idea. So we will error. Oh my goodness, I don't know what's happening. Okay, so I'm going to end this one, and I will reschedule. I'll put up another one in for about an hour, and we will completely switch it up, and we'll talk a little drama. How about that? Because there's lots out there, and there's a bunch of stuff that we could probably take a look at, for sure. I cannot see chat. Oh my God, what's going on? Oh, page unresponsive. Oh my God, I don't know what's going on. Okay, so I hope that you guys can hear me and that you guys are, don't just like wonder why the hell this live all of a sudden stopped. So I'm going to stop. Let me just give me a second. Actually, I can go on chat on my phone. Okay, I am going to stop and then come back. Okay, so I will schedule another one, and we'll see you guys in a little bit. Thank you for being here. I apologize for this morning. I mean, this live was just a shit show. But hey, that's okay. Whatever. It's the way it goes sometimes. So, okay, I will see you guys in just a little bit. All right? Okay, love you. Okay, bye. Let me just give me a second. Actually, I can go on chat on my phone.